Welcome to the State of Psychedelic Law in Canada 2025. My name is Jay Katz, and I'm the Executive Director of the Psychedelic Association of Canada. And thank you so very much for joining us today to find out about what is going on with the law and psychedelics in Canada. Uh, some of you are members of the PAC, some of you are visiting us today. The PAC, the Psychedelic Association of Canada, exists to awaken a revolution of well-being across the country by getting legal access to psychedelic medicines for all Canadians. We do this by building public awareness, by advocating with lawmakers and regulators, by encouraging harm reduction, and by building a strong community. We've made much progress in Canada and around the world. The medicines are gaining more prominence and helping more people than ever, and there's still a long way to go. A lot of lawmakers aren't certain what psychedelic medicines are and what they're used for. Be a part of the solution, be a part of our team. Help us. You can do that by becoming a member. I'm going to put a link in the chat right now, which will allow you to join our team and be a member. Please do that. This is vital work, and it's going to change the way we take care of mental illness on the planet and the way that we deal with ourselves and our society and one another. So join us at the Psychedelic Association and help us get to an awakened enlightenment across Canada and for everyone. We have four guests today, experts in psychedelic law from across Canada. We're going to save our questions for the end because this is always a very interesting panel, and we want to make sure that everyone has a full chance to tell you all about what's happening in their area of work. And so we'll save the questions for the end. There's a special Q&A box as opposed to the chat box. So when you have your questions, if you could please put them into the Q&A box, then that's really helpful because it helps us find them more easily. And so you see our panel before you. They are from across the country. I'm going to let our legal experts introduce themselves and tell you a little bit about themselves. We'll go in order of the speaking today, and we'll start with Nicholas Pope. Please tell us what you do, where you're from, and what you're going to talk about today. Thanks, Nicholas.
Hi, I'm a lawyer at Hamid Law in Ottawa. I practice primarily charter litigation and administrative law, which is the review of government actions and decisions. And today I'm going to talk about a case that I worked on last year and is actually sort of ongoing in a second iteration of it. Jody Lance, who was a cluster headache patient requesting access to psilocybin.
Thank you, Nick. Our next legal expert in our menu of the country's top psychedelic law legal experts is Rob Laurie. Rob, if you can tell us where you are and what you do and a little bit what you'll be talking about today.
Hi, good afternoon. My name is Robert Laurie. I'm with Adlucent Law Corporation. I'm on the west coast of Canada, and yeah, similar practice to Nick's. But yeah, I'm involved with quite a lot of well, lately, the last 5 years, Indigenous representation in the areas involving cannabis, psychedelics, cigarettes, and other constitutional related challenges. So yeah, exciting to be here. Thank you.
Uh, and thank you for joining us, Rob. And still, we have more experts in psychedelic law. Next on our agenda is Mark Goldgrub. Mark, please let us know where you are, what you do, and what you'll be talking about today. Mark, you may be muted, Mark. I'm not sure if others can hear you, but I can't.
How about now? Okay. Something was up with my headset. Anyways, I'm based out of Toronto and I focus more on the corporate and regulatory side of psychedelic law, working with companies, nonprofits, professionals, and other practitioners as long as they're operating legally. And I'm licensed in the US and Canada, so I'll be talking a little bit about what's going on in the US since there's a little bit more activity going on there, especially right now. and what the impact of that is on those of us north of the border.
Well, thank you, Mark. And still, we have more experts for you. And so next we have David Wood. David, please let us know where you are, what you do, and what you'll be talking about today.
Thank you very much, Jay. Happy to be here. My name's David Wood. I'm a lawyer and patent agent. I'm practicing out of Calgary, Alberta. My client base is national. I split my time between Cygen, which is a licensed dealer and manufacturer of psychedelic drugs, and my own legal practice, R Group Legal. I'll be speaking today about changes to regulations under the Controlled Drugs and Substances Act, and then also a couple clinical trial highlights where I talk a little bit about Lycos. And Mark, if that's part of your discussion, that's I'll compliment whatever you say, and then just a couple other clinical trials I thought were really interesting and worth bringing up, and a sign that our regulator here in Canada is open-minded, and that's always great to see.
Thank you, David. And this broad, diverse, and highly accomplished and knowledgeable collection of legal experts is one reason why it's such an exciting time to be in the psychedelic space right now. Things are happening everywhere. We're going to start today with Nicholas Pope. So, Nicholas, please tell us more.
Sure. So yeah, as I mentioned, I'll talk about the case of Jody Lance and his background for it. So right now, under Canadian law, the way people can get access to psychedelics, that's MDMA and psilocybin that I'm talking about there. But I'll limit my remarks just to psilocybin for today, is through the Special Access Program. And it's a program where a doctor or a nurse practitioner submits a request to the government, Health Canada, and then they use their criteria of whether it's a medical emergency and the person's tried and failed a sufficient number of other drugs, and whether there's enough evidence for the specific treatment that's being requested, and then they can approve or deny the request. And what we've seen so far is that they've been approving requests for psilocybin for end-of-life distress and treatment-resistant depression, but not any other conditions. And so I had a patient come to me, Jody Lance, and he suffers from cluster headaches, which are often known as suicide headaches. They're, according to some literature, the most painful condition known to humanity. And he had tried all sorts of different treatments. And his neurologist actually told him about psilocybin after so many different treatments didn't help him because the neurologist had had a patient for whom it had worked. And so Jody tried psilocybin and it had a positive effect. It didn't cure his headaches or anything, but drastically reduced the pain when he took it, and perhaps had some sort of effect at reducing them, but that's always hard to tell, of course, without a clinical trial. So anyways, he found this sort of regimen that worked for him, different amounts at different times, and so we decided to submit an SAP request so he could do it legally. And we did this and we requested a dosage of 12 milligrams of pure psilocybin twice a day for 4 days upon the onset of an acute cluster attack. And there's no literature saying that this is a correct dosage. There are no clinical trials, nothing like that. The clinical trials that deal with psilocybin did 10 milligram dosages once every 5 days for 3 times. But we requested this, and we thought there's a high likelihood that it would be refused. So we really bolstered the application. I submitted very extensive charter arguments. We had an affidavit from a second expert, a chronic pain specialist, one from a pharmacist, lots of evidence of clinical trials. We submit all of that, and predictably, Health Canada refuses the application. But before they do, a pharmacist with Health Canada has a phone call with the neurologist, and in that phone call, says to him, and we got this recorded, that one, safety has been established for psilocybin, and two, I know it worked for the patient. So then it was odd when the refusal came back, and it was just 2 sentences long, which was the norm up until this point. Because I had been submitting charter arguments on lots of different patients' SAP applications. I have sort of this canned court case in a box that any doctors that I deal with, I get them to include a link to that. That way, that will be part of the record if it needs to go to court. But Health Canada just has been ignoring all those submissions and those charter arguments. And same here, they just say, well, you haven't provided enough information about safety and efficacy, despite the pharmacist saying that safety is established and he knows it works for the patient. And the patient hasn't necessarily tried all of the conventional treatments, which under the SAP you don't have to, and under the charter you don't have to as well. But so we bring an application to federal court for judicial review. We go all the way through that process. We go to court, and this was last May 2024, and we win the case. And the thing is that the decision was so bad, Health Canada's decision was so bad that the court didn't have to say that Jody Lance had a charter right to psilocybin in order to let us win. Just the fact that Health Canada completely ignored our charter arguments was enough to make the decision unreasonable. And so the judge sent the decision back for redetermination by Health Canada, which is the normal remedy in administrative law. It's very rare that the judge directs what's going to happen. And on redetermination, Health Canada approved the request. So Jody got his psilocybin, he took it. It worked really well. We kept extensive records of the treatments, and there were drastic reductions in his pain scores. So that's where we're at now. And what we've seen, I'll talk a little bit more about Jody in a second, but the implications for the system is that Health Canada has realized they can't just ignore charter arguments. So we saw after that when they refused people, they started adding on these annexes, maybe like about 2 pages of bullet point notes to kind of explain their reasons for refusing someone from SAP a little bit better. It was still, they've still been bad, in my opinion, and not legally compliant. But they're working a little harder to refuse people. And they say that they're acknowledging the charter and considering it, even though what they're actually doing is they're using their sort of framework of analysis under the SAP, the question of whether it's a medical emergency, rather than the questions under the charter, which under the charter, people have the right to make reasonable medical choices. And you can see that there's a difference between something being an emergency and a reasonable medical choice. You could be making a reasonable medical choice without there being a medical emergency. So they're still doing it incorrectly. But then what we saw is after we won with Jody Lance, we submitted another request for a different patient for cluster headaches, slightly different dosages. And that patient was recently refused just a month or two ago. And there we saw a 10-page single-spaced decision refusing it, clearly not written by Health Canada people, clearly written by lawyers. So we're seeing that Health Canada is really pushing back now. They don't want to open up the floodgates to all these different conditions, but they can see the writing on the wall because people have charter rights, and they're doing what they can and putting a lot of effort into stopping it. And I think it's annoying in the short term, and it makes it more difficult for patients, but it's a good sign that they're a little worried that things are going to change. And I think that's a good sign for us. If they think things are going to change, that's positive. So back to Jody Lance, we submitted a request for another series of doses in December. And we've just been waiting on Health Canada to render a decision on that for quite a few months now, over 4 months. We recently filed a mandamus request in federal court, which is just a court application to compel them to render a decision because it's been so long. Whether it's a yes or a no, that's not really part of this court case. I filed a lot of these. I filed over a dozen of them for psilocybin in the past few years, and every single one of them gets resolved before a hearing, and they just render the decision within a month or two. So we should probably get a decision within the next month on Jody Lance's second dose. And there's going to be one of two outcomes here. Either it's going to be approved, so Jody will get his treatment. That's great. And it's going to make it even harder for Health Canada to refuse him in the future, because once they've approved him twice, to take away something they've been giving to him or allowing him to have is going to be seen as a lot worse in the eyes of the court. Or they'll refuse it. And in which case we'll go to court again, and I'm hoping that if we go to court this time, because they'll be writing a big long decision, we'll be able to win this case on the basis of the court saying Jody Lance has a charter right to psilocybin, not your reasons are deficient, Health Canada. And the goal there will be that once we get a court case that says somebody has a charter right to psilocybin, then that won't need to be something that needs to be established in all court cases going forward, is that at least some people in Canada have this right. And then court cases can focus more and more on tearing down these barriers, like how slow the decision-making process is for the SAP, or whether it should even be an SAP at all, or whether people should only be allowed access to these two products, filaments and Cygens, and not natural mushrooms or different dosages. And we can start tearing down all these barriers and eventually get it out of the SAP program once we have that precedent. So we'll see what happens with Lance going forward, but sort of step one of a three-stage process of removing barriers has happened here, where we've got Health Canada start acknowledging charter rights. Now we just need them to analyze them properly and admit that there are charter rights, and then tear down the barriers. So that's getting near the end of my time. I'll wrap up there and be open to questions once we're in question period.
Thank you, Nick. I'm sure there will be lots of questions. And this is how we make change, sometimes one brick at a time. Next, we'll be hearing from Rob Laurie. Rob, thank you for joining us today. Eager to hear what you have to say.
Thank you. I should also add, I'm dealing with a disc injury in my neck, so I've got screaming nerve pain down my left side. So if I seem a little shorter or more aggravated or grumpier than usual, there's the reason. But yeah, as indicated earlier, I cut my teeth, I guess, representing dispensaries, and about 10 years ago this time, I was just in the early days of representing at one point about 40% of the unlicensed illegal cannabis dispensaries before legalization. And the interesting thing is, when that ended in about 2018 or so, I had Indigenous clients who had approached me, and they said, hey, we've seen what you can do with medical patients. What do you think you can do with Indigenous constitutionally entrenched arguments, and try to bring in the United Nations Declaration of Rights of Indigenous Peoples Act arguments? And I looked at it and discussed, and in BC at least, the fourth level of government is Indigenous, and if it's certainly not fourth, it's on par with provincial and toe to toe with federal and a lot of issues. And well, what's interesting is you can make all the same arguments that you could with medical patients, with section 7, life, liberty, security of the person, but finding that you again have access to potential section 35 inherent Aboriginal rights. And if you look at the sale of cannabis, that might be one thing. But if you expand the discussion back a little further and look at how cannabis is defined under the Cannabis Act, it's at Schedule 1, includes all phytocannabinoids from cannabis and non-cannabis derived sources, regardless of process. So that technically you've got plants, non-cannabis sources where you can obtain phytocannabinoids. Kale and echinacea are traditional examples. Well, another word for coneflower is echinacea, and echinacea is a phytocannabinoid, and certainly not on the West, but throughout Eastern, Central, and Eastern Canada, coneflower, also known as cone or echinacea, is pretty prevalent. And so technically, an Indigenous individual making a tincture or some form of cannabis as medicine and looking at it as such, where does that extend to? Technically, an Indigenous individual making an echinacea tincture would require a processing license under the strict wording of the cannabis regulations. But there is no exemption for food, social, or ceremonial purposes. And that's kind of left the government with, not too sure of how this could all play out with respect to a recent decision called White and Montour, which is looking at that could potentially restate the Vanderpeet test, which is the test for acknowledging an existing Aboriginal right. And so, where does cannabis fit with all that? Well, in BC, there is a number of bands too that I can think of: Okanagan Indian Band and Kamloops, which in their written language have words for hemp and cannabis. So again, there is an acknowledgement of that. And so looking at other established rights such as agriculture, foraging, gathering, where to what extent can these arguments be made? And the interesting thing is with indigenous arguments, provided you have indigenous leadership willing to support your arguments to an extent, in addition to court, there are negotiations and opportunities to discuss some of these opportunities in a less formal environment, certainly less formal than court. I like those environments. I certainly think you can get a lot more done than the latter. But the interesting thing is now you're seeing cannabis being sold in proximity to tobacco, as well as in proximity to, well, psychedelic compounds and mushrooms and so on. And it's interesting because you're seeing on raids, clients of mine who get raided, the BC government deals with the cannabis. The federal government certainly steps in to deal with the tobacco under the excise, but no one wants to touch the psilocybin. The provincial enforcement, they're usually not going to want to touch it and think that the feds will do something, and usually the feds won't. And so the interesting where all this is leading to is that, well, the opportunities to amend the laws, change the laws, and get further toward that line of reasonable, dignified patient access, I think can get far when you align the indigenous arguments and approaches with the earlier procedures that Nicholas set out, talking again to the administrative processes as well as constitutional charter litigation. I mean, what I've learned in 10 years of doing this is, provided you can satisfy two words, which is, show me where it says you can do this, or show me where it says you can't do this. And then these issues involving tobacco, cannabis, and psilocybin as they apply to activities on indigenous land remains to be seen. And why UNDRIP is quite interesting is that extends or widens the scope of arguments to not just ban lands, which is crown land, but under UNDRIP, the definition extends to traditional land. So in the case of Corey Brewer, who already had licenses from his band, sought their approval and authority to open up off reserve. The airport and downtown Vernon, that's all traditional land as far as they're concerned. And so the interesting thing is that, the clients that I represent have no problem pushing the line and, seeing where those lines are. What I've noticed in this over the last 5 or 6 years is there is kind of a double standard. I mean, if Nicholas, David, and I were to open up a store and be selling illegal tobacco, psilocybin, and cannabis, we'd probably be dealing with preliminary procedures and so on. With Indigenous, though, it's all, a lot of the time they don't want to touch the case, or they're not sure how to do it, or there's a call from upstairs that this smaller skirmish, they don't want to get in the way of something further on up the ladder or the totem pole, so to speak. So it's an interesting way to really. The first question is, to me, when I show up, usually after or during a raid or after a raid, is for the government is, hey, what are you planning to do? What's the, what's your, what do you want out of this, right? Because really what you'll see is no one's getting charged. And the interesting thing is they'll go in, they'll remove what the externality, whether it's the cannabis or the psilocybin or the contraband tobacco, they'll remove that. But whether then they extend any further is different. Whereas again, that analogy of David, Nicholas, and I opening up a non-indigenous on on non-reserve land. I mean, yeah, we would be looking at a whole host of criminal remedies, as well as potential provincial civil forfeiture and other means that government are taking to, in non-indigenous circles, go after situations of unexplained wealth, where again instances could determine that. But in the indigenous case, those lines are not so clear. And so where things are at, we have been working with I've been working with a number of indigenous owners, their bands, and working with trying to establish connection with other bands facing similar issues in Canada to see if we can, deal with a collection of these issues in a federal reference case. I mean, at the moment, we're dealing with Corey's issues with the community safety unit. Those are provincial. And we are sort of treading water to see where do we want to go with this, because ultimately we don't want to deal with any of this in provincial Supreme Court. This would be better dealt with in federal court, because in that instance, if we're able to use evidence from BC, evidence from Central Canada, evidence from Ontario, evidence from Eastern Canada, which there is a lot of interesting evidence involving cannabis, that again, at least that give the opportunity to make arguments that, well, maybe a lot harder for Health Canada and certainly the federal government to avoid dealing with. And that's really where I think we're at with legal psychedelics. And I'll conclude on that note is it's sort of the tale of two cities. You've got the legal city, that's, where the legal roots, but you've also got enough sources competing with what's legally available that it's almost comical. But ultimately the government and the courts, in not coming to a conclusive determination on these issues, are leading to situations where sooner or later Nicholas is, going to file the right application, and the right circumstances coupled with his existing fact pattern and the evidence will end up inching towards the recognition of rights, or charter recognized rights. But the difficulty is that at the end of the day, our rights are not absolute. Any charter right, if it can be established, is still subject to minimal impairment. And as it applies to tobacco, cannabis, and psilocybin, I think there's a lot more generous arguments that can be made in courts that, again, judges will give, certainly in cases that we're looking to bring, greater deference, provided we can establish the constitutional hurdles of standing, much greater than when I was representing independent cannabis stores, where the best thing that we had to rely on was was sex worker jurisprudence, which at the end of the day, all built on and backed into the charter and issues of life, liberty, security of the person. I'll leave it there. My shoulder is killing me, and yeah, I look forward to any questions
So,
at the end.
Rob, thank you, Rob, and thank you for being brave to come despite your shoulder. I'm reminded also of the courage of both yours and Nick's clients. It's not just the determined, professional, focused, well-planned legal work that you're doing to put these bricks on the walk to legalization, but also the courage and commitment and conviction of your clients for believing in these medicines and putting their own necks out there to make it happen. So thank you for that. And still, we have legal experts with lots of great information to reveal for us. The next is Mark Goldgrub. Mark, thank you for joining us today.
My pleasure. Okay, everyone can hear me this time? Okay,
We
I got
can.
my headset working. Okay, I'm gonna do a little PowerPoint presentation to make things a little more entertaining, which I like to do. Okay, so every year my firm releases a State of Canadian Psychedelic Law report. This was the cover of this one. If you want to read this report, which covers a lot of the things we're talking about today, you can find it on psychedeliclaw.ca, and you can also find it on greeneconomylaw.com. So this presentation is for educational purposes only. It's not legal advice. You guys all know this. You know a little bit about me. I operate in Ontario, licensed Ontario, New York. Okay. So we're going to talk about a couple things. We're going to start talking about US psilocybin legalization because that's kind of where a lot of the march of progress is happening. We're going to talk about the FDA rejecting MDMA therapy. This was a really big deal. We're going to talk about the Trump administration, and we're going to talk about Canada. So let's start with psilocybin. So psilocybin is now legal, or in legal, being legalized, has legislation has been passed to legalize it in Oregon and in Colorado. In both cases, there were ballot measures and they passed, and they basically established statewide programs where people could access psilocybin therapy. Both of these programs were more what I've heard called wellness-based programs rather than medical programs. They did not require a diagnosis or referral by a doctor. In both cases, you can basically go apply to the program and get psilocybin therapy, not because you need it, but because you want it. It's already launched in Oregon, and it should be launching this year in Colorado. So Massachusetts tried to do the same thing, and it did not work. They had a ballot measure last year. It lost by 57 to 43. There's a lot of speculation as to why. Some people say that the results in Oregon were not exactly inviting, and Massachusetts didn't feel particularly inclined to follow them down that pathway. We'll see if the results in Colorado are any different. Some of the complaints about Oregon were that it was just too expensive. Part of the problem there, in terms of the expense, is one, it's very new. Everybody's taking a huge amount of risk. Insurance, incredibly expensive. You're trying to get that covered for psychedelics, generally speaking. And you couldn't deduct anything federally, any expenses federally, because psilocybin is federally illegal. And cannabis, it seems like there's always a little bit of movement there in terms of trying to grease the wheels. How can we make this business work? Where the federal government sort of allows it to happen, even though it's not legal. But with psilocybin, that is not the case yet. So the costs involved in running the program were huge. The costs involved in people applying to the program were very exorbitant. And then everybody started screaming that it's inaccessible, which is true. There are reasons for it. So Massachusetts just passed. They didn't pass the bill. They passed on having their own program. But very recently, just the other week, New Mexico legalized regulated psilocybin use. But they didn't do so by means of ballot measure. They did so by means of legislation. They had something called the Medical Psilocybin Act. It passed the state legislature, was signed by the governor, and it is going to establish a medical program, not a wellness-based program. This is really a program where you actually do need some kind of diagnosis. And there's some interesting commentary about what this means federally. Catherine Tucker, who's a very influential psychedelic lawyer in the US, she had a great LinkedIn post the other day saying that actually, because this is a medical program, it sort of is for complicated legal reasons. I would highly recommend you follow her on LinkedIn. But she was explaining that there's some way that this actually pushes the federal government to accept it. Interesting stuff. So the march of progress continues. It sort of felt like things took a real step back with Massachusetts. There was also legislation in California to decriminalize psychedelics, which got vetoed by the governor. Gavin Newsom did say, if you send me a medical bill, I'd be very interested. Hasn't happened yet. But it's kind of a little bit hopeful that after Massachusetts, the ballot measure failed, that in New Mexico, they've kept the march going of progress. So the FDA rejecting MDMA. This was really interesting. So, we'll cut to the end of the story. In June 2024, there was a Lykos application for MDMA assisted therapy. Lykos is a for-profit arm spinoff of MAPS, which hopefully everybody knows, a nonprofit group that's been working in the psychedelic space for decades. So when I was talking to US lawyers about this application, the Biden administration basically issued some kind of press release or something saying that they wanted to legalize MDMA, and if the FDA had approved this application, it would have functionally created like a medical MDMA. So a medical legalization. Lawyers I was talking to in the US were like, this is a done deal. They've basically signaled that they're planning to approve it. I'm not a conspiracy theorist, and I don't think there was any kind of conspiracy to foil the application. But I definitely was not as confident. I was thinking, don't be counting your don't count your candy kids until they've shown up at the party. And yeah, basically what happened was there was the FDA has an advisory panel, and the advisory panel issues advisory opinions to the FDA, basically like a commission that approves or denies the application of therapies, drugs, etc. So the FDA doesn't have to listen to the advisory panel, but they usually do. And the advisory panel came out very strongly against this application. They said that there was problems with the way the trials were designed, and they cited a need for a more rigorous phase 3 trial. I didn't find this that surprising. Some of this is things I hear behind the scenes about Lykos and whatnot, but I didn't find this super surprising. In any event, there were a lot of people who did find it very surprising and were shouting that this is some conspiracy theory, the government's never going to allow psychedelics to be legalized. I think there probably were just issues with the trial. So it seems like they could try again. I don't know if they will because it's so unbelievably expensive. They might wait for change of circumstances. Maybe they'll try again under this administration, which is a very different approach to things. But yeah, it was really a shock. The psychedelic community, which I know a lot of people joining us are part of it, was pretty taken aback by this rejection. So you may have noticed that there's new management in the US. So things are a little bit different. The new management is kind of a little interesting when it comes to psychedelics, because on the one hand, it's a Republican administration. You've got conservative, you've got evangelicals, you got a lot of religious people who, in the past at least, were not super pro psychedelics. Now we're actually seeing some interesting exceptions to that. Like, for example, Rick Perry, who was not too long ago on Joe Rogan talking about how great ibogaine is. And yeah, definitely not exactly your classic new age atheist or anything there. So, but you do still have people who are are conservatives and totally not drug advocates, or psychedelic advocates, or drugs of any kind, mind altering substances, let's say. On the other hand, then you have these more colorful people who are part of the administration, the most kind of notable of which is RFK Jr., who, how this guy ended up in a Republican administration, considering he, before he became an anti-vaxxer, was mostly known as an environmental lawyer, a very staunch environmental lawyer. I remember watching this guy in a documentary about mountaintop removal. So yeah, interesting character. He has gone so far as to berate the FDA for aggressive suppression of psychedelics. Elon Musk also um, has, on many occasions, said that he is very pro psychedelics and famously is a big fan of ketamine. So, what the general policy is going to be coming out of this administration with regarding psychedelics, we don't really know. It seems like there's a lot of people jostling to move things in this direction or that. The early signs have been positive. It does seem like, from what I'm hearing about, like people crossing the border, it seems like if you tell border guards you're coming to the U.S. for a psychedelic conference, that's fine, as long as you're not posting on social media anything they don't like about Trump. But as long as you're posting about psychedelics, I haven't heard any problems, which is very different from in 2018 when we legalized cannabis here. We were hearing stories of people who were being asked if they'd ever smoked weed and potentially being denied entry. So things do seem a little different this time around. There's some interesting characters, but it is still a little early to see what does this actually mean for legalization, what does this actually mean for the FDA, and so on and so forth. We're going to be watching and we're going to be waiting. What about Canada? What does this all mean for us here in Canada? Well, I don't have any phenomenal, mind-blowing conclusions. I think that the fact that we're seeing things continue to move at the state level, I think it's good. It keeps the drumbeat going in Canada, where it feels like progress has totally stalled over the last couple of years. It felt like for a couple of years things were really moving, and other than basically what Nick Pope and Paul Lewin are doing, it doesn't seem like anything is actually moving forward in Canada at this point. So it's good that in the U.S. we do see things moving forward among the states, and maybe federal, we'll see, but definitely among the states. So that keeps something to look to and point Canadian politicians to. Hey, this train is moving, and we can either be on it or we can be off of it. Another interesting thing, which I didn't really talk about in this presentation because there weren't any huge movements around it, but one thing that I really find interesting is that whenever I'm talking to American psychedelic lawyers, the focus is so much on religious use and legalization through the courts, making arguments based on religious grounds. And there's been some interesting work done, including successful work done, to get tribes or churches exemptions, or basically make it legal for kind of narrow instances of religious use. In Canada, I actually would love for, maybe Nick can talk a little bit about this in the Q&A. Maybe you can't, I don't know. We've talked a little bit about this, but in Canada, we focus a lot on medical legalization. We focus very little on religious use in terms of what happens in the courts. There is a history of religious use arguments in courts in Canada, but it's not a good history. I don't know of any court cases where religious use of any psychedelic was approved, and there's some cannabis cases which the courts rejected religious arguments, not because they didn't say there wasn't infringement, but they basically said that prohibition was justified under Section 1, this kind of saving clause that allows the courts to say, yeah, there's an infringement, but in this case, it's reasonable. I don't know if that same argument came to courts today, with regard to ayahuasca, who's a really good case, not like a wink, wink, nudge, nudge case. I'm not sure what would happen, especially if there's continuing good law in the U.S. we can point to. But it's also interesting that in the U.S., they don't do the medical arguments to the courts at all at this point. It seems like that's something they really are not focused on at all. Maybe this tells, something a lot about the priorities of the two countries. In the U.S., they're so much more focused on religious rights than, basically healthcare for everybody. And here in Canada, we're less focused on religious rights, but we're like, hey, but everybody has a right to healthcare. So that's my presentation. And if you have any questions, comments, I know we have a common question period. You can also email the firm at info at Green Economy Law and check out our websites. And that's all.
Thank you, Mark. It's interesting to see how progress happens on both sides of the border and how the pendulum swings one way or the other, not always in unison. As we build even more experts to come, David Wood will tell us more about some things that are happening internationally and give us a summary of some things in Canada. David, thank you for joining us today.
Yeah, my pleasure. And won't be too international, I'm afraid, but I do have a bit to add on the Lycos point, but I'll stick to my sort of planned approach here. I have Canada's going to update its controlled substance regulations. So just for people in the audience that are not lawyers, part of what the law can be and usually is legislation that the federal or provincial governments write and then make into law, notional law, and probably law. Ask Nick, but and Rob for sure. But the point is the law in Canada that applies to all controlled substance, any activity at all with controlled substances, is the Controlled Drugs and Substances Act. And the Controlled Drugs and Substances Act says things like, if you possess a controlled substance without an authorization, there could be, there's a criminal offense, for example. I think we all know this. And it's under the CDSA that exemptions issue. And I think probably a lot of people here know that an exemption is a thing that allows a specific person to do a specific activity with a specific substance that's obtained from a specific place, like feed a restricted drug to mice and learn how much it takes to do something to the mouse, like kill it, or put it on cell culture and see what happens to serotonin receptors, that kind of thing, or in a clinical trial, provide it to people. Underneath the CDSA are regulations. Regulations are different depending on whether they apply to narcotics, like morphine, or controlled drugs, like amphetamine, or targeted substances, like benzodiazepines, or restricted drugs, like LSD. So we're going to go from 4 different sets of regulations to 1, which is actually, the overall impact won't mean people can do anything they can't currently do, like buy psilocybin in a store. That's not compliant with the law. It will remain non-compliant with the law after this change. But the change indicates that there's an expectation there will be more access through things like the SAP, which is great. Like the change makes it easier to work with controlled substances in Canada, like Cygen does. Cygen has a Part J restricted drugs license. We don't make any drugs other than restricted drugs or drugs that aren't controlled at all. We don't make controlled drugs. We don't make narcotics. We don't make targeted substances. But after this change, if we do, it'll all be under the same act. On our end as a dealer, it will become a bit simpler administratively. And there's a ton of changes. I can't really address them all in 5 minutes, but the ones I like the most are how some of the exemptions that have to apply only to MDMA and psilocybin, and only, if it's meeting all the other requirements of the class exemption, like it can't be outpatient, like Nick's client with the low dose, or actually, I wasn't really low dose, pretty high dose actually, daily use for cluster headaches. They've codified those exemptions, which is great. So the dealer to practitioner and then practitioner to patient, whether they're selling or administration, are just codified under the controlled substance regulations after this change happens. A bit simpler. What I like about it is the fact that it being, for example, an exemption for a patient where there's special access will be codified and made permanent and part of the law. It just suggests that the government's recognizing that will happen probably more, not less, and might as well remove red tape. Like I like what it suggests, assuming the law is amended the way it's currently proposed. Makes things a bit simpler for pharmacists too, which is great. But most of those simplifications do not apply to restricted drugs. They would apply more to things like Adderall or prescription painkillers, anabolic steroids, uh, sleeping medication. I don't know any examples of sleeping medication, thankfully. Ambien, there you go. So that's great. We're simplifying things a bit. Just wanted to kind of say what those regulations are, what they're not. They're not something that makes it easier for a person to just get their hands on a controlled substance because they want to. It has nothing to do with that. It's all about administrating how the current licenses work. And that's appropriate for what a change in regulations should be. And then I'll just briefly talk about some interesting clinical trials. The Lykos one, I mean, Mark described it well enough. I'm pretty close to the end of my time. So all I'll say about it is I do agree that it does not make sense for the FDA, which is analogous to the Therapeutic Products Directorate of Health Canada, HHS, which might be renamed, is Health Canada. And then under that, you have the FDA and the DEA. In Canada, we have Health Canada, and then the Therapeutic Products Directorate and the Office of Controlled Substances. So the FDA said, we're not sure about how the therapy, exactly was done, and we don't regulate. There's a lot of focus on the fact that therapy as a practice of a profession is not regulated by any federal agency, because it isn't. They regulate drug products. And I just found it confusing that impacted the decision so much, or appeared to, at least, was pointed to by a lot of actors. There's a lot of people with an opinion on this. I understand that one of the criticisms was the lack of an MDMA only zero therapy control group. There's all kinds of things you could say after that statement. I'll leave that to your imagination, but it's a great point. And then another thing that I found funny was the lack of adverse event reporting for euphoria, which occurred in virtually 100% of the active arm. I guess no one thought of that as an adverse event. I find that comment, just delightful in a special way. And I'd like to just quickly, before I wrap up, talk about two clinical trials in Canada. I don't agree that nothing's happened in Canada. I just believe that a lot of what has happened, look up the Lance case. And, I know there are a lot of good trials that are getting approved here. And while I wish the SAP group would be more forthcoming than they are, and I wish they'd stop blaming the FDA rejection of Lykos as a reason to reject MDMA SAPs, which I understand is happening, or used to, at least. It's strange to me that a regulatory conclusion would impact evidence that was already there, especially given the nature of the rejection. I'm encouraged that we have at least one company that's managed to get ethics approval and no objection letter on a clinical trial that'll involve the patients paying for the drug that they're going to be given, psilocybin. Pretty interesting. I think the fact that it's connected to Therasil, it's a different company that's sponsoring it. That's just a company that was made to do this, basically. And I think the fact that it's tied up to a nonprofit and does not involve product development, probably off paper has something to do with it, but that's just a personal theory. Interesting, though, that that it is ethical for them to defray the costs on an open label, unblinded, only active arm study. And then another one that's quite fascinating is a group called Chi is going to provide MDMA for people that have completed MAPS training or Lykos training. And I really am happy that that's happening, because even when, I hope, I'm going to just say when, I just don't know the timeline, MDMA is a prescription drug that be given to people. It will start and probably end for a long time with therapy, as it should. And we're going to need a lot of people that are good at that. That's all. I don't think I need to make the point more broadly. But I'm happy to see that there's a trial where that's, going to happen, and get some people trained fully. So that's all I have. Very grateful to be here. Looking forward to any questions.
David, thank you. It's fascinating to see the many different pathways and the many different levels in which the law can be examined and perhaps shown to be flawed or deconstructed to make these medicines legal. I'd like to just say that it's extraordinary, the expertise and the knowledge that we have in the psychedelic space and on this call today. Thank you. And the courage of your clients for stepping forward and doing this. And so I think we should all give a virtual hand to everybody. Thank you so very much. There's huge opportunity in everything that you said today. We do have some questions. So what I'm going to do is I'll read the question, and then if one of our experts can just speak up or raise a hand and let us know that they'd like to answer that question. So the first one is from Shayla, a pharmacist in British Columbia. And she says, as a pharmacist with psychedelic assisted therapy training and ongoing education, and what can I do to further the legalization of psychedelics? I actually want to have a well-trained pharmacist to be able to prescribe. Could I use a lawyer or some kind of legal way to get the movement going? Is there anyone who would like to give Shayla's question?
Sure. That's awesome. You want to help. And I like to think of psychedelic drugs as already legal because at Psygen, we have a lot of MDMA and a lot of LSD and a lot of DMT. And those are all scheduled, and psilocybin, and nothing's illegal there. So I just like to never call it that, and I do appreciate that a lot of people have suffered badly because controlled substances are controlled, and I recognize that they're controlled, but there's nothing inherently illegal about them. It's just their possession is typically illegal. But to actually address your question, those new regulations will actually make it a lot easier for what you're going to do. I would, unless you really want to, discourage trying to Google that, and also discourage paying anyone to tell you about it because they're not the law yet. But the general gist is pharmacists will be able to do more, except with restricted drugs. Psychedelics are pretty much all restricted drugs, depending on what you think of ketamine or PCP or dextromethorphan. Other than those, most psychedelic drugs are restricted, which means you can't really work with them right now as a pharmacist unless you're also a licensed dealer. But when the regulations change, you will have expanded scope to practice professionally with them. If you want to actually work with them as part of training, that's an interesting idea. You could probably actually do that with an exemption because you would just have to possess the material, I guess, compound it. Change it if the exemption let you do that. Exemptions get weird about altering substances, but because that's technically production, right? To put material into a pill is now producing, and you're not a dealer, and kind of breaks the system. So you could just apply for a clinical trial. Not even clinical trial, just you'd want a research project where you receive material and do something with it, like formulate something that doesn't involve giving it to humans. You could do that right now if you wanted to as part of training, as long as Health Canada said yes to that plan. And if that's something you're interested in, anyone on this call could help you, and talk to your college. Definitely talk to your college.
Thank you, David. We have another question. What are the legal implications for non-Indigenous registered healthcare practitioners who wish to support psychedelic-assisted therapy with Indigenous peoples? Is the location where the therapy occurs, for example, on or off reserve, a determining factor in whether charges might be applied against the practitioner? Who would like to answer that one?
That's got to be wrong. No?
Sorry?
I think we need a backup, Rob. I would vote for Nick.
Oh, okay.
Or you, Mark. You're already on mic.
No, the Indigenous is like definitely an area I would I would give to Rob if he's not available. Then yeah, I would give it to
Yeah,
Nick.
no, and Rob was brave enough to join us with a sore shoulder. Nick, are you comfortable chiming into that? Or if not, we can ask Rob and perhaps email you an answer if that person wants to give us their email address.
Yeah, I mean, I can't speak too much. Sorry, I'm trying to enable my video, but it's disabled by the host. Maybe someone can remedy that.
Yes,
Oh, there
because
we go. Okay. Um, I like there's really for non-Indigenous people wishing to support Indigenous peoples, um, in mo most practical reality, you're going to have to follow the same legal framework as anyone else. Rob was talking about how maybe police are more reticent to lay charges on Indigenous people, that sort of thing. But technically speaking, it's no different. You need your exemptions. You need to go through the SAP. Otherwise, it's illegal. Um, that's pretty much the short answer.
thank you. Um, and so we have a box full of questions um, from Brendan. There's this question: does anyone have an update on the person from Calgary who was a recipient of a SWAT team raid for receiving a shipment of bark? I remember reading about that case in the news. Does anyone have any insight or any update on that case? Okay, that was easy to answer. Sorry, Brendan. Um, and here's one for Rob. In a time from Ian, in a time of more patient-centric care, what is the role of informed consent to enable the patient to choose the minimal risk of psychedelic assisted therapy over MAID?
It's a big one. I know that Spencer from TheraSil is in either his capacity through TheraSil or otherwise is part of that committee. And I know that there's a general idea that if you're in the sort of even in the realm of MAID, you ought to be able to maybe see if you change your mind after psychedelics. Like that should be an option. That's the general logic of it. And maybe Nick knows more about this than I do, but that's my understanding. I have no idea how that is between just an idea versus policy. I don't know where that is in terms of being part of how decisions are made. But I mean, Nick is our SAP expert nationally, and by our I just mean the countries. So, maybe he'll know more.
Yeah, I don't have any info on, say, like the ethical concerns here of MAID, but what I'll say is I like to use it as a legal argument when going to the SAP, and more, not so much the SAP because honestly, they just ignore most of our arguments anyways, but to prepare for going to court because I think that can be highly persuasive with the court. The SAP, they'll say, well, we're not the made people. We don't make made decisions. All we do is we interpret our little piece of legislation here. But when you go to the courts, uh, they probably will look a little bit more at that and say, well, wait, the government's letting people die without trying every single treatment versus you have to try every single treatment before getting psilocybin. Something's up here, and that's what we're hoping to rely on in especially these cluster headache cases. It's a lot um, with non-mental health disorders, right? Because like cluster headaches, it's a lot more persuasive because right now you can't get made if your sole underlying condition is a mental health disorder. They put in place legislation to change that, but they've deferred it twice, and it's not coming into force for at least a couple more years. I mean, they may defer it again. So right now, it's not a huge thing for, say, treatment-resistant depression and end-of-life distress. Or I guess treatment-resistant depression, simply because you couldn't get made merely for treatment-resistant depression.
Uh, thank you, Nick. Um, Here's a question from a veteran who engages with people at Veterans Affairs Canada, I'm guessing frequently. He'd like to know what information is there that would be helpful in appealing to people at Veterans Administration.
I without being sort of a political advocacy expert, but some experience in that realm. I would say just real human stories. That's what you go to politicians with. Going to them with legal arguments is not as helpful. They care much more about the human story, about the effect that psychedelics have had on people's lives, especially veterans, as you're saying, um, the suffering that veterans have had to deal with, and the illness, and then the massive improvement that it has for them. So those are sort of stories you want to share.
Nick, do you think they'd respond to evidence? Like if you had journal articles, if you had,
Yeah, that's the other thing too. And I think depending on sort of the stripes of the politician, some of them might be, they'd be cautious to say, well, we should just kind of legalize this, but they might say, well, let's put more funding towards more clinical trials. Let's make it easier to do clinical trials. That's maybe the better route for some versus other politicians will be more likely to go all in on, yeah, let's just make this legal.
Yeah. And I think I can add to that with our own advocacy work. Certainly at the VAC and in the Senate, the Veterans Affairs Commission, it has been much easier to get people interested in funding more research. And sometimes that's the thin edge of the wedge, and we know what the research will reveal. And so we also talk about more funding for more research because that will in the end be very helpful. Um, Here's another question. I have a client that obtained MDMA for work-related PTSD through the SAP process. 3 doses were released and had an impact on their PTSD scores, but did not resolve the issue. The patient has reapplied, but there's no response yet after 3 months. Might there be an additional charter argument if someone is in the middle of a treatment arc? Any experience with renewal or second applications?
Yeah, I can speak to that for sure. So Health Canada has not really been approving renewal or second applications when people have been requesting that beyond the first, because you can request, as you say here, kind of 3 doses when you request it, just because that's what some trials have done. You request a second course of 3 doses, and they'll come back to you with a question saying, well, show me the evidence that a second course of 3 doses is good, and you may not be able to find any clinical trial that has that second course, and so they may refuse you. I did recently have a patient, this was for psilocybin, but same issue, where he had gotten access through a Section 56 exemption back before the SAP was opened up to psilocybin, and done a number of treatments, and then applied now under the SAP, and they refused him initially, partly because of this. Oh, it's a second course. Uh, some complicated stuff. We filed a court case, and then we also applied for a new SAP for a different indication. The first one was for end of life distress. This one was for treatment resistant depression. Who knows exactly what went on there, but perhaps the combination of us having this pending court case on the other application and then filing this new one to give them sort of an out, they ended up approving it. But that wasn't a second SAP, but it was a second course. So it seems like there might be some wiggle room there, but there's going to be a lot of pushback. In terms of chart arguments for kind of uh, interrupting something in the arc, absolutely. The only thing is you need to get your evidence. So, and that's something lawyers can't do. That's something that the academics and the clinicians and everyone needs to do. So, if you were wanting to proceed with something like that, I'd say really put together that sort of evidence package of all the scientific evidence about interrupting the course of a treatment arc, evidence from the patient and yourself about um, exactly what profound negative effects it's having on them to interrupt it in the middle, that sort of thing, and then present that all to Health Canada as part of the SAP. Because one thing everyone should know here, if you're ever dealing with SAPs or any administrative law thing in general, you can't add new evidence once you're in court. Every scrap of evidence you want to rely on, except for a few very rare exceptions, needs to go to the initial decision maker. You can't just apply casually once you get refused, then bolster your court case. No, it's over at that point. You need to proceed as if you're going to have to go all the way to court right from the first step. Otherwise, you won't have the right evidentiary record.
Thank you, Nick. Another question about MDMA. Um, is there an MDMA plus therapy study making its way through approval in Canada, or perhaps the MDMA plus therapy study? And what will it take to get something like that approved in Canada?
The phase 2 of that study was partially in Canada. Actually connected to some of the same individuals in a good way, because there were some issues with that specific site. But some of the people that behaved professionally, which was most of them, that were involved in that study are running the training one now in Vancouver as well. And Lycos has said that they plan to do another study. I don't know if they'll locate part of it in Canada. I don't think there'd be any reason they wouldn't. It's they certainly understand Canada, but and then I believe, I'm sure someone's going to do a study with MDMA in Canada. I'd be surprised if that didn't happen.
Thank you, David. And so let's make one last call for questions. If anyone
I
has,
I
go
have
ahead.
I have questions I would want to ask Nick actually.
Well,
Okay.
yeah,
I
the
think
space
I
the
think
space is yours. Here we are.
okay. Yeah, Nick, like stop me if you can't talk about this stuff, but what are you seeing in terms of religious arguments in Canada?
Uh, yeah, I can't talk about that.
Ah, okay, Nick's working on it.
Uh,
I think I had another question for you. Yeah, why is Health Canada, why does it seem like there's been a real withdrawal? Like it seemed like things were moving. We got SAP approved. We had a bunch of, or we got psychedelics eligible for SAP. We got, Section 56 exemptions for psychedelics happening. It felt like for about 2 years, things were moving. And now it feels like everybody's really tightening up. Is this political? What is this? What's going on here?
I mean, I don't know the underlying reasoning, but I can tell you what I've heard formally in some rejection letters for SAP,
Better
as
than
well
nothing.
as have heard this informally. And so I actually believe it's not a pretext. I believe it is their real reason. Perhaps there's some other, reasons as well. But they say that and I believe them, that they're concerned about the SAP becoming this sort of way to circumvent the drug approval process. They want, if psilocybin and MDMA are gonna be used for medical reasons, they want it to go through the standard process, go through the trials, get approved as a drug. And so that's why it was fine when just a couple people were applying through SAP and they approved the first few. And those people, they push back, oh, you didn't try ECT, but you know, they wouldn't push back on as many things. And some people who kind of maybe would get refused now were getting approved back then. Now that more and more people are applying, things are going faster, different people, like I know working with Theracell, we have sort of templates and automation and all this sort of thing to sort of ease the enormous burden of doing an SAP request. And so Health Canada's seen these templated answers, and they're really pushing back on all that because um, there's just too many people getting approved,
Hmm.
which is not the point of the program, right? They should be assessing each individual person. Are they in a medical emergency? Yes or no? But it's pretty clear that they're saying, nah, too many people are going through this. We're worried that, like, say, Filament and Cygen are then getting around having to approve their drugs and just letting everybody go through SAP, which is nonsensical because both those companies are providing their product for free through the SAP. So obviously the companies aren't trying to circumvent the process here.
I'll add to that we don't have a product. Cygen, we don't develop drug products. That's not what we do. We donate API, or we sell API, or we sell research material for people that have a piece of paper that says they're allowed to have it. So, I mean, with our donation, that's not even a possible motive. And
Oh,
I do
oh,
think it's interesting, though, that whatever the change in the regulations, to whatever extent you can look at that and read any intent into it, they've not only made the exemption for restricted drugs that are accessed through any authorization, they don't say SAP, permanent, that's all restricted drugs. So you don't have to apply for an exemption for anything as long as there's an SAP. So they put the decision squarely where it belongs on the Therapeutic Products Directorate, and the OCS doesn't even have to get involved. So it's nice that they made it administratively simpler. And I'm also encouraged by the fact that when they kept saying, "Hey, you should do a clinical trial instead," right at the start, and I don't necessarily agree. It's not up to me to agree. It's up to whoever I'm advocating for to decide how they feel about a clinical trial. But it is encouraging what kind of trials are being allowed, and the level of effort that's being required to make it happen is encouraging. So I see that progress, I guess.
Okay, I have one more question for Nick, which is what's going on with the Hartle case?
Yeah, it's still kind of frozen. We're still awaiting. I'm not really sure what's going on with it. We're still awaiting a ruling from the judge on the preliminary issue. Um,
Hmm.
Once we get that, we'll have to sort of relook at where we are because the world has changed since we filed that case, and I imagine some amendments will need to be made to the case. I mean, our main claimant has died, so some
Yeah,
things are gonna change.
yeah. Shout outs RIP to Thomas Hartle. Jay, okay. For everybody watching, I'm not looking at the chat when I'm doing my presentation. So when I was presenting, I have a full screen with my slides, and then after I see, hey, we can't see your slides. Like, well, I need you to tell me that while I'm presenting. Don't put it in the chat because I can't see it. Jay, can I try again and see if everybody can just see what I,
Well,
was
you,
working on late at night?
Mark, if it's any
I
consolation, if you're really paying attention, you got a flash. You just saw it for a moment.
well, and so we're sort of late in the time we have. Your presentation was riveting despite the technological glitch, because the lesson that I'm learning in life is that I do not own my technology, it owns me. And
Uh,
so I'm always relieved when I see people smarter and younger than I am also being owned by their technology. And so I'm sorry it didn't work because I know how much work you put into it. But as it turns out, Mark, you apparently didn't need it nearly as much as you might have thought you needed it.
well,
So,
there were some
so
very
thank
it was
you.
all the pictures were 32-bit, like funny pictures, like
And
video game characters. So I feel like
well, we're sorry we missed it. If you want to send it to us, we can distribute it to people who saw
yeah,
the
I'll
video.
send it, and
And
maybe
and
when
someone,
you send out the
yeah,
thing, just say if you want to see what Mark's slides should have looked
right.
like, click on
There
the
we go.
thing.
And so
Yeah.
someone here, in fact, said they loved it. We have another question in the chat. Someone asked, is it legal in Canada? Oh, there was a, hang on, thing scrolled. There we go. Is it legal in Canada to hold iboga retreats? This person says there are churches that have been formed in the US to administer iboga from tribes from Gabon. Can people go down a similar route in Canada and form churches and administer iboga here? Can a lawyer assist in this process?
I can answer that one. I posted a link to our page on psychedeliclaw.ca on I Begin in Iboga. Basically, it's not legal. However, iboga is also not a prohibited substance. Iboga and ibogaine are not prohibited, but they're they would fall under the definition of drugs under the Food and Drugs Act, and distribution of them with or without consideration, even if you were holding a ceremony, you gave everything out for free, that would still be basically like it would be like giving away or selling an unregulated drug, which is legally what's happening. So I know that these things are happening and have happened actually for a long time in Canada, but they're not legal.
Thank you. And
And yeah, just to add that if any kind of healthcare practitioner was involved in that, they would also be jeopardizing their license for sure.
and then we have, I think, time for one more question, and there is a new question, so this will be the last one of the day. Someone asked, can people take 5-MeO DMT, I think this person means legally in Canada.
If you possess it personally, there's no contravention of the law to possess a substance that's not scheduled. You should email status at the Office of Controlled Substances and ask them if they consider it to be scheduled, just to make sure. And I actually asked law enforcement about this once. I said, what if someone had a bag of white powder on them and you confiscate it and they say, hey, that's insert reach, that's not scheduled. I'm allowed to have that. The police officer, and he knew this right away. It was interesting. He said they send it to a lab. And if status says that is not scheduled, then if there's any left after the test, you get it back, which is fascinating. But it's just like Ibogaine, except it's not. I mean, I don't know if it's naturally sourced or not. Probably not. And the 5-methoxy, but it's the same thing. You cannot give it away. But if you already possess it, and if status agrees with you that it's not controlled, I'm not status, then because it's not listed, but that doesn't mean it's not controlled. So as long as status agreed and you had the substance in your possession, I think you'd be free to do whatever you want with it. But you can't. If you give it to someone, you're taking a leap. And were you just sharing with your buddy, or were you running a business? I don't know, but he's dead now, and I know it's not. It doesn't kill you, but you might make a crazy decision shortly after doing it. That's happened. I think, and that's the other thing about all these sort of quote gray area. To me, not like none of them are gray, but that's just my view of it. It's all illicit if it involves transfer of any unapproved drug, or if it involves possession of a controlled substance, full stop, subject to constitutional rights. And the thing is that no matter how much you rationalize and how much you live in Vancouver, where just everything's different, if someone gets hurt or breaks something on camera, then you'll find out how legal it is.
And so
if I could
go ahead, Mark.
Yeah, basically, I agree. My view is it's not a listed substance. So not legal advice, none of this is legal advice, but when people ask me about it, I say I don't see any issue with, possessing it, but yeah, you just can't give it away. Don't do a ceremony with it, giving it for free in any kind of creative way is not really going to effectively get you around the law there. But it's not a prohibited substance. Ironically, some people tell me that Ibogaine and 5-MeO-DMT are the strongest psychedelics, and I tell people, it's more illegal to microdose like 0.25 psilocybin, which you will not feel at all, or you're very unlikely to feel it. That is more illegal than doing Ibogaine, which could trip you out for like 12, 24 hours, or 5-MeO-DMT, which is only 50 minutes, but apparently incredibly strong. It's very ironic. There is a little bit of a difference between 5-MeO-DMT and Ibogaine, which is that Health Canada has explicitly put out a little notice about Ibogaine, and I'm not aware of any explicit notice about 5-MeO-DMT from Health Canada.
Also, it's on the prescription drug list, and all that means is that if it's ever approved, it cannot be over the counter or an NHP. So they, that's in the same vein. I'm surprised 5-methoxy is not also on that list, but because I've heard the same thing, that it's remarkably powerful. And it's interesting. I met with someone who's starting a charity to send people down to Mexico to receive these treatments. And this man is a former RCMP, and the only psychedelic drugs he's ever taken in his whole life are Ibogaine and 5-methoxy DMT. They're also the only 2 tattoos he has. It's and yeah, when you hear people who've been helped by those 2 chemicals in particular talk about it, or MDMA, it's amazing. Like I think there's a real important reason that this webinar is even worth having, and that Mark and Nick and Rob and myself are comfortable being legal counsel working in psychedelics outside of a criminal defense context. And that's because it's readily apparent that for most people, the correct amount just might not be zero. And that'll be therapeutic. And and some people think it's also just part of wellness. And it'll be interesting to see what happens in some of these US states as a result.
I it's and the clock is ticking. This is the perfect time. The three of you and Mark are and Rob are trailblazers. A special shout out to Rob, who endured great personal pain to be here. He had to bow out. But thank you, Rob, for joining us as you could. Thank you, all three of you. I think if people have specific questions or want legal advice, they can find you all easily on the internet. As always, bringing such knowledgeable people together is a fascinating education on what's happening with psychedelics legally in Canada and around the world. Thank you so very much for joining us. We do appreciate it. I hope everybody was as excited by all this as I was. There's a lot of information here. Enjoy the rest of your day. Check out our other events, and please help us get legal psychedelics for all Canadians. Join the PAC, be a part of our work, and be a pioneer in your own way and a trailblazer, just like David, Nick, Mark, and Rob. Thank you all for joining us. It's a great pleasure to put this information out there.
Are there still tickets to your party on Monday?
There are still tickets to our party on Monday. For those of you who are in Vancouver, we are celebrating the progress we've made to date with a party and fundraiser hosted at the home of Joel and Dana Solomon. Tickets are $200. They can be acquired on our website. Paul Stamets will be there, Pam Crisco, Jillian Maxwell, lots of pioneers and leaders in the psychedelic space. Please join us. It's going to be a great time, and it helps move our work forward. And David, we'll see you there. Thank you.
Yeah.